Morning.
Good morning. How are you doing?
Doing fine.
Good, 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 good.
How you like your new chair?
It's going well. Feels better than the one I had at home when I had been working under quarantine.
Good to hear.
So good deal. All right. Do we have everybody on this particular hearing, Mr. O'Brien? And I can't see, is it Mr. Clark?
It is.
Okay, all right. It just has Jeff on the screen there, so I want to make sure. So we have Mr. Clark and Mr. O'Brien. I am Judge Purdy. I'm going to be presiding over the hearing today, actually the new judge of the 95th District Court.
Sure.
So I understand that we have the plaintiff's objection and motion to strike a controverting affidavit of Marilyn Pacheco. I know Mrs. Rouse is on. Let me make sure that we have the cause number so we have a complete record. This is cause number DC 20-01251. May I have the parties just announce briefly, just let the court reporter know your name and who you represent in this matter.
Sure. It's Jeff Clark, represent the plaintiff Capitillo.
Thank you, Mr. Clark. Good morning.
This is Cale O'Brien on behalf of defendant Jeffrey Don Preston.
All right. Thank you, Mr. O'Brien. All right, I've had an opportunity to take a look at the objection and motion to strike, as well as a copy of the response. So I'll hear from the movement as it relates to their motion to strike, and then I will give the other side an opportunity to respond.
Sure. Judge, we say two things. Number one, the Dallas Court of Appeals in 2001 struck an orthopedic surgeon in that Turner versus Peril case, saying just because you're an orthopedic surgeon doesn't make you qualified on other specific areas of the medical practice. In that case, there was chiropractic treatment, there were MRIs ordered, there was imaging ordered, and other things. So the long-lasting rule in Texas has been that it's apples to apples. You have to be a doctor qualified in the area that you're going to give a controverting affidavit on to controvert the reasonable necessary charges. And in this case, the controverting affidavit is filed by a non-doctor. She's not an expert on any form or fashion in the medical field, not pain management, not anesthesia, not anything in the medical field. And Cale has sent me a copy of a Supreme Court case that he cited in his response. And that Supreme Court case doesn't deal at all with controverting affidavits. Those words are not even in that case at all. What it says is that the subrogation company can file an 1801 affidavit. They can file the affidavit themselves because the statute says that a custodian can do that, and they imply that the subrogation company can do that. So that case doesn't stand for the fact that a non-medical expert can controvert a 1801 affidavit. The case that he cites out of East Texas, I don't understand it. It's different than the Dallas case, and I don't understand the court's reasoning in that case. So it asks the court to follow the longstanding rule in the Fifth Circuit, which is the Turner versus Peril case. Number two, if after 19 years and technology and internet and databases, the world is all different, okay? If it is different, that a non-medical expert can pick and choose from different databases and say, based on databases, this is not reasonable. We still get to the same result. On paragraph 19 of Ms. Pacheco's affidavit, she says the FIA references in all these medical bill audits that she's used, there's 4 different databases. The fee references are not based on Medicare or private payer rates, okay? Ms. Capitillo is a private pay person in this case, as far as the pain management medical treatment she received, the injections, the rhizotomy, and so on and so forth. She's a private pay patient. And Ms. Pacheco says in her affidavit, I don't deal with private pay. Everything I'm giving you on these databases is health insurance related. So she can't be an expert by her own testimony concerning private pay medical treatment, which is what Ms. Capitillo got. Okay? Even if she didn't have that in there, you've got her picking 4 different databases, insurance databases, all with different results, and all saying in a general geographic region that includes Dallas County, Texas. But it's not specifically tied to Dallas County, Texas. It may include Oklahoma, it may include New Mexico, it may include Arkansas. It doesn't say in her affidavit. So you have her with different databases up and down, not specific to Dallas County. And finally, she says, based on the 75th percentile of these insurance databases, I determine these dollar amounts. She doesn't pick 90%, she doesn't pick 85%, and she doesn't show why she picked 75% rather than 90% or whatever percentage would be a higher figure for Ms. Capatillo. So we say, look, there's a Court of Appeals case that I've cited numerous times down here, and that's the law still in the Fifth Circuit. It's got to be apples to apples, qualified to qualified. Even if it's not, Ms. Macheo says, I don't do private pay. And that's what Ms. Capatillo is private pay.
All right, thank you. Mr. O'Brien.
Thank you, Judge Purdy. So let me just break it down a little bit. Marilyn Pachinko is a certified professional coder. So we asked her to look over the $98,000 in medical bills that the plaintiff had incurred, and we asked her to opine on whether or not that was reasonable or not. We know she's not a medical expert. We're not asking her to opine on the necessity of the treatment. We purely wanted her to use her experience and skill and databases that she has access to make a determination as to whether or not those $98,000 in treatment was a reasonable charge. And she did that. She, has access to these codes, these CTP codes. She has access to the 4 databases that he references, and she can compare them based off of geographic location and other treatment providers in terms of their reasonable reimbursement rates for those same CTP codes in those regions. And that is what she did. And she came to a conclusion. She explains her methodology in her counter affidavit, as well as in additional exhibits. I didn't include them in this response because there's a volume of pages. If you'd like to see that, you're welcome to. It's on file, but I didn't respond with her methodology in this particular matter because that's not what's being challenged here. Mr. Clark basically is taking issue with the fact that she's not a medical expert. And we agree she's not a medical expert, but that's not what she's being asked to opine on here. It's purely just the medical bills. Now, in Gunn versus McCoy, it's the Supreme Court case from Texas from 2018. And the Supreme Court has carved out a very lengthy explanation for why they allowed an insurance adjuster to be determined as an expert for reasonable reimbursement rates. They even say that non-medical experts are often more qualified to do this than medical experts because medical experts often don't do their own billing. And that we believe that that's accurate from our experience. So that's why in 2018, there's this breakthrough case that basically allows non-medical experts to come in, review bills, and determine what's reasonable as far as charges go based off of the CTP codes that are referenced in the medical bills that the plaintiffs have incurred. So Marilyn Pachinko, with over 30 years of medical experience, medical billing and coding experience, over 15 years of just experience negotiating with insurance companies as far as reasonable reimbursement rates, has been more than qualified to look at these bills and compare them with all of the databases that she has in her systems to determine what's a reasonable value. And for that reason, she is qualified. Texas law has allowed this to happen. And even so forth, the other court case that Mr. Clark took issue with was from the 12th Court of Appeals. And the reason we cite that is that the 12th Court of Appeals says that a nurse, so not only do we have an insurance adjuster being an expert, but now the 12th Court of Appeals has said that a nurse can be a billing expert as well. So based off of the same matters where they have access to these these databases that have what reasonable reimbursement rates are for these medical charges. So basically it's a check. It's a check on the fact that these medical providers can't just charge 4 times the amount of what a reasonable reimbursement rate is for the same CTP code that they're billing these patients. So we believe that Ms. Pacheco's counter affidavit reflects her credibility as an expert in the field of opining on this reasonable necessity, reasonable charge. And we believe that her counter affidavit complies with the requirements of 18.001.
Let me just ask a question before I allow Mr. Clark to have a brief response. And this question is to Mr. O'Brien. I have to go back and look through the actual affidavit. I know it is attached here, but the issue was brought up that the codes that I guess your expert was looking at did not necessarily cover private pay type of patients, I guess, if you will. So can you address that particular argument? If she's looking at all these other codes that are out there for patients that typically are Medicaid insured and all of those and how they're paid, if there were no comparisons done to a private paid type of patient, what is your response to that, Mr. O'Brien?
So what Ms. Pacheco looks at is the actual, what they consider to be reasonable reimbursement rates for these charges. Doesn't matter if it's private pay or not private pay, because I don't think Ms. Capatillo has paid anything. So we're not saying that it shouldn't really matter as far as private pay versus insurance pay. Ms. Pacheco says, here's what this CTP code reflects as far as the charge that's a reasonable reimbursement rate. And that's what her analysis is based on. She's not doing this comparison of private versus not private. So I think that issue shouldn't necessarily matter, especially if Ms. Capatillo hasn't paid for any of these things. And she's asking the defendant to, pay for them. So.
Okay, no, I appreciate that response. Mr. Clark, I'm gonna allow you to have final words since you are the movant as it relates to this motion.
Sure. What private pay means, it means not insurance. That's what it means. She doesn't have insurance. So all the databases that have been used by Ms. Pacheco reference health insurance payments. And, some are high, some are low. It appears that she takes the 4 and averages them together. But again, if the court please, if she's just dealing with health insurance reimbursement rates, that doesn't apply. That's not apples to apples to our case. And even if it was apples to our case, you've got somebody, it could be a college math student, it could be a high school math student, just goes to a database and says, here's one of 100 databases, let me pick this one and pull out the information about what a reasonable CPT code procedure charge is and apply that for a geographic region. And Dallas County, there's nothing in the affidavit that says these are reasonable charges in Dallas County, Texas, which is what the statute requires her to say. So it's a geographic region, and you can't tell from the affidavit what the geographic region is, whether it's the southwest part of America, 5 states, 10 states. If the court please, it can't be the law is what I'm trying to say as far as being able to pick codes and so forth and so on. It just can't be the law. And even if it was, she didn't do it right. So Ms. Capatillo is a private pay, and there's nothing that ties this to Dallas County, Texas.
Mr. Clark, just a question for you. As I read the motion and the response and heard the argument this morning, even though there is an agreement that Mrs. Pacheco is not, or Pacheco, if I am pronouncing her name correctly, is not a medical expert, is she opining as to the care that the person received, or is she opining as to the reasonableness of the bills?
The latter.
Okay.
But what 1801 says, look, is you file your 1801 affidavit as the reasonableness and necessity of the charges in the medical treatment. You have to have somebody that's qualified on the back end to say these charges were not reasonable. And all this person is doing, if the court please, is she's going to a database it's not her idea that this charge amount is excessive or this charge amount is not reasonable. She's going to an outside database. And if you really had this line of reasoning, she would have to show that she's qualified to pick the correct database or pick a group of databases that are well recognized as far as being the proper valuations in Dallas County, Texas, where this medical treatment was provided. So I don't think the theory is correct, but even if it was correct, she hasn't properly applied it because there's nothing in the affidavit that shows she's qualified to opine on reasonable medical charges in Dallas County, Texas for a private pay patient.
Okay, all right. Well, gentlemen, I know that I have orders from both of you as it relates to the motion that is before the court today. I am going to have a ruling for you all by the conclusion of today. The way that you will receive my ruling is I will sign whichever order that I do enter, and I will push out a copy of my signed order to you all via email, and it will be uploaded to the court system. So you all can anticipate receiving that by 5 o'clock today. All right. Is there anything further that the court needs to hear on this matter?
Oh, thank you so much, Your Honor.
All right. Thank you. Stay safe.
Thank you, Judge.
Take care. Bye-bye. Good morning.
Good morning.
Let me start. I don't know why my camera went off. There we go. Good morning.
How are you, Judge?
I'm doing great. How are you?
I'm doing very well.
Right.
So how are you settling in?
I am getting settled in fine. Just having a few hiccups with computer issues, but you know, we're still moving it along.
It is the interesting times.
Yes, yes, very much so. Hello, Mr. Bennett. How are you this morning?
I'm well. Good morning, Judge.
Good morning. Good morning. Good to see you. Do we have everybody on the Zoom hearing that we need to proceed this morning, or are we still waiting for a few others?
Well, Mr. Paccioni, the
I see him just connecting now.
And I've talked to both Mr. Kane and Mr. Paccioni that we're having difficulty getting in touch with my client, Mrs. Spagna.
Okay.
Her phone's going straight to voicemail, which is strange. So I don't know that she's going to be here today.
And do we need her for testimony, I would assume?
Yeah, I think usually I wish we didn't. And I talked to Mr. Paccioni about potentially doing this by submission instead, and we could get an affidavit from my client so we don't have to set another hearing and do it so the court can decide it on submission on our own time.
All right. Let me ask you with respect to that affidavit that you're proposing and to do it by submission. First, let's just make sure we're on the record. I know Mrs. Rouse is on here, the Zoom hearing with us, even though the camera is off, but this is cause number DC 19-05810. Is it Amani Jahiri et al. Versus Ariello A. Martinez? It's set this morning for a minor prove-up. I just would like counsel at this time to announce on the record their names and who they represent, and then we can talk about how we should proceed.
Charles Bennett here for the plaintiffs.
Dave Piccioni here on behalf of the defendants.
Erwin Kane ad litem on behalf of the minor Angel Garcia.
All right. Okay, thank you. So, Mr. Bennett, I understand that we may have some difficulty. You have not been in contact with your client, or you're having some problems reaching her with respect to today's hearing. Is that correct?
That's correct. Her phone is going straight to voicemail. Mr. Jodry, we've contacted him. The divorce, they're officially divorced, so I don't think can help. And she, Miss Espana, is named as the next friend for their child. Her child.
Okay. We talked a little bit about possibly getting an affidavit from your client and setting this for submission so that the court could review it. Are there any damages, though, that would be included in that affidavit that would not be liquidated? Do you know the answer to that?
I think, well,
because the only reason why the court asks is because obviously if you submit an affidavit by submission, and if there are damages that the court is able to just ascertain by the simple math, and they're not conclusory, I can certainly grant those. But if there are some damages that are not liquidated, it does need to be by a hearing, and it does need to have a record. So that is the court's concern. I don't mind resetting this until we can do that. But I want to be efficient with everyone's time.
So I think about a third of the settlement for the child is medical bills.
Okay.
And then the rest would be, I guess, considered pain and suffering, which would be unliquidated.
Okay.
And that might be a problem for what you're suggesting, although the affidavit could mention, and I think some of the other documents that we've already submitted mention the fact that the child was in some pain and mental anguish following this, and that's why they sought medical treatment, and that's what the medical treatment was to address. So I don't know.
The mental anguish is not really, if that's the only thing, then that's not really an issue. But what about any type of future damages or any future things that this child may be needing?
No, I think we're covered by that. The settlement is just the medical bills and then the past pain and suffering and mental anguish. Is that, the other attorneys on the line, is that about right?
Your Honor, just historically, this is a automobile collision.
Okay.
And the minor child was young, and went to, I think, for chiropractic referral for a couple of visits. That's really was it.
Okay.
I think Mr. Kane can validate the fact that the child's the minor's made a complete recovery. So it's on balance. There are larger cases on your docket to address. All right. I'm not trying to minimize the minor's claims here.
No, I certainly understand, and I appreciate the candor with just letting me know the types of damages that we're dealing with in this particular case. Mr. Kane, do you have anything that you would like to offer to the court? And I guess, is there an agreement as it relates to the ad litem fees? There's not an issue with that.
No,
so it looks like this is likely a good case to submit by submission. Am I hearing that from all counsel?
Your Honor,
go ahead, Erwin. I'm sorry, I didn't mean to step on you.
No problem. Still getting used to this virtual platform stuff. Your Honor, I presented the court an ad litem report that lays out the damages, that lays out the injuries, that lays out the current status of the minor and my recommendation. I think that answers the question about the damages.
Okay.
The proposed judgment sets forth the agreement on attorney's fees. So really all we need to do, I think, at this juncture is just to get Ms. Espana's testimony on the record. And I don't see that it would be a problem by submission so long as all counsel agrees on the affidavit, that's going to be submitted.
Okay. All right, then why don't we do this, Mr. Bennett? what I can do, I'll go ahead and give you all a reset date some time out, just so this case comes back to me and it doesn't just go away in an abyss somewhere. And I know I still have my handle on it, but I'll give you all some time in which to get that affidavit and to submit it to the court so that it can be done by submission. And I'll give you some certain date in which to do that. If not, then the court will send out another notice of hearing for like a status conference to get it done, just so that way we know it's done. Is there anything else that I would need?
I don't think so, Your Honor. Thank you. That sounds like a good plan.
Okay, and I will make sure that the clerk, as soon as she gets here today, well, the clerk is here, the coordinator. When the coordinator arrives, I'll make sure that we get you a new date, probably some 60 to 90 days out. Does that sound, that should be more than enough time to get an affidavit and to submit it to the court. And assuming that it does get here before that 60 or 90-day reset, then we'll take you off of the court's calendar system. But if I don't receive anything, then I'm going to expect everybody to appear on this Zoom hearing again so we can figure out how to move this case. Okay?
Sounds good.
Fine, Your Honor.
All
Your
right.
Honor, I think the only thing that you would be expecting from us then is the affidavit, because I think the judgment, the CSA,
Correct.
my application for fees, and my report have been filed. Is there anything else the court is going to
No,
beyond
you
the
are correct, Mr. Kane. I have the order here, your report. I have the agreed final judgment that was submitted. I guess if we have all the signatures on there. Mr. Bennett, do you know does your client need to sign that agreement, the agreed judgment?
The agreed judgment, I did not put a signature page for Mrs. Tanya. This is Mr. Piccioni speaking.
Okay.
I just put the attorneys, the settlement agreement, which has not been submitted to the court, will have her name on it.
Okay, that's what I wanted to make sure. That's what normally we do, all the signing after we do the prove up. So I just wanted to make sure we weren't forgetting any steps here. Okay, no, I have everything, gentlemen, that I need other than this affidavit. So again, you can anticipate getting a reset date by the coordinator, but in the meantime, make sure that that affidavit gets to me. You can just direct it to my attention in the 95th. Let them know it's for submission before Judge Purdy, and the court will review it. And if it agrees with everything therein, it'll get it signed for you.
Okay, we'll get on it.
All right, that sounds good. Thank you very much, gentlemen. And that concludes our hearing.
Thank you, Judge. Happy New Year.
Thank you. Happy New Year.
And by the way, Your Honor, congratulations on your new, your ascension to the bench.
Thank you. I appreciate it.
I haven't had the privilege of appearing before you in quite a while.
Oh, well, thank you. I appreciate it. So hope to see you again soon. Take care.
Okay. Bye-bye.
Bye-bye.